Trial lawyer, Grace Go, case manager. I am prosecutor Fatou Bensouda.
Thank you very much. And the defense?
Mr. President, Your Honours, good morning. Mr. William Ruto, who sits behind me, is represented by David Hooper of Queen's Counsel, Esafal and Shamla Alagendra of Counsel, Miss Lee Laurie, our legal assistant, and at the back, Andrew Mora, Shalini J. Raj, and Grace Sullivan, who are members of our trial support. Your Honours, my name is Kareem Khan QC.
Thank you very much.
President and Your Honours, Mr. Sang is present, and his defense team is constituted of myself, Katwa Kigan, Caroline Boisman, Logan Hambrick, Judy Miongi, Philemon Koech, and Joel Bosek. Thank you, madam.
And for the victims?
May it please Mr. President, Your Honours, I am Wilfred Nderitu, counsel for the victims. I am assisted by Mr. Ochlon Narantsegseg from the OPCV and my case manager, Ms. Caroline Hatzig. Thank you.
Is there any representative from the registrar? I say, Mr. Deputy Registrar at the back, if you can also introduce your team.
Monsieur le Président, Madame, Monsieur.
Mr. President, Your Honours, we have Peter Venave-Becker, coordinator at the court services, and I am Didier Pereira, representative of the registrar.
We are convened to commence the trial of Mr. William Samuel Ruto and Mr. Joshua Arab Sang. As a preliminary matter, it may be of some assistance to take a moment to review briefly some of the milestones along the procedural road we have traveled to arrive at the phase of the case that begins today. The origins of this case are the 2007 elections in Kenya. In the aftermath, the prosecutor on the 26th of November 2009 requested authorization from the pre-trial chamber to conduct investigations into what is known in ICC terminology as the situation in Kenya. On the 31st of March 2010, the pre-trial chamber granted the prosecutor the authorization to conduct the investigations as requested. As part of the unfolding proceedings, the prosecutor requested the pre-trial chamber to issue summonses to 3 individuals, requiring them to appear before the court. The individuals are William Samuel Ruto, Henry Kiprono Kosgei, and Joshua Arab Sang in this case. We are not talking about what happened in the companion case. By a majority of the pre-trial chamber, a decision of the was rendered on the 8th of March 2011, issuing the summonses to appear. Summonses to appear, or a summons to appear, is a judicial mechanism that aims to secure the attendance of accused persons before a criminal court without the more aggressive method of arrest warrant and detention to secure such an appearance. On the 7th of April 2011, the 3 persons mentioned earlier as the subject of the summonses to appear indeed voluntarily appeared before the court in their initial appearance. The accused in this case remain under the regime of the summonses to appear and have always appeared whenever required to do so for purposes of the proceedings thus far, and on some occasions even appearing of their own accord without being required by the court to appear. At the stage before the commencement of trial, the Rome Statute does not require accused persons to always appear before proceedings unless directed by a chamber to do so. On the 31st of March 2011, the government of Kenya launched a challenge before the pre-trial chamber, arguing that the case was not admissible before this court. The legal basis for such challenges is Article 19, read together with Article 17 of the Rome Statute. According to those provisions, a case is not admissible to be tried at the ICC if, among other reasons, a state with sovereign jurisdiction over the crime is investigating or has investigated or is prosecuting or has prosecuted the case. But admissibility is not precluded where the state in question is unwilling or unable genuinely to carry out or genuinely to have carried out the concerned investigation or prosecution. In its admissibility challenge, the government of Kenya argued that it could fulfill its primary responsibility as a state party to the Rome Statute by exercising criminal jurisdiction over those responsible for the international crimes allegedly committed in the present case. In other words, the government argument was that it was willing and able to investigate and prosecute the case. On the 30th of May 2011, the pre-trial chamber rendered its decision on the admissibility challenge. It dismissed the challenge. In dismissing the challenge, the pre-trial chamber found that the evidence presented before it did not demonstrate that the government was, quote, taking concrete steps showing ongoing investigations against the three suspects in the case, unquote. Therefore, the pre-trial chamber held that the case was not, quote, being investigated or prosecuted, unquote, within the meaning of relevant provisions of the Rome Statute. Furthermore, the pre-trial chamber held that any investigations anticipated by the government did not, quote, cover the same persons subject to the court's proceedings, unquote. On the 30th of August 2011, the appeals chamber confirmed the decision of the pre-trial chamber in the appeal of the pre-trial chamber's decision dismissing the admissibility challenge. From the 1st to the 8th of September 2011, the pre-trial chamber held proceedings in order to consider whether or not to confirm the charges that the prosecutor had drawn up against the three men that I mentioned earlier as the subject of the summonses to appear. On the 23rd of January 2012, the pre-trial chamber issued its decision on the confirmation of charges. In that decision, the pre-trial chamber, by a majority, confirmed the charges against two of the three men in the persons of Mr. Ruto and Mr. Sang, finding that there were substantial grounds in the evidence presented before the pre-trial chamber to believe that the two men are criminally responsible for the crimes charged. It is important to stress that this does not mean that the two men have been found guilty as charged. The pre-trial chamber's confirmation decision of charges is only a manner of saying that the case of the two men must proceed to trial for a trial chamber to conduct proper judicial inquiry with greater depth, at the end of which findings of guilty or not guilty may be entered. As regards the third man, Mr. Kosgei, the pre-trial chamber dismissed all the charges. The third judge in the pre-trial chamber dissented. He found that none of the charges should have been confirmed against any of the three men because the events charged as crimes do not rise to the level that deserve judicial inquiry before this court. According to him, those were events best left to national prosecuting authorities to deal with. The charges having now been confirmed against Mr. Ruto and Mr. Sang by a majority decision of the pre-trial chamber, their case was transferred to trial chamber 5, as it used to be, for purposes of preparing for and conducting the trial. The preparatory work done by the trial chamber 5 included considering and disposing of a very large number of applications by the parties on various matters. The applications included one by the counsel for Mr. Ruto, requesting that he be excused from continuous presence during his trial. It is to be noted in that regard that during the investigation of this case against him, right through the confirmation of the charges against him, up to the transfer of his case to the trial chamber for trial, and the trial chamber's setting of an initial date for the trial, Mr. Ruto was a private citizen of Kenya. But earlier this year, he was elected the Deputy President of Kenya. In consequence, his counsel brought an application requesting the chamber to excuse him from continual presence at trial in order that he may continue to perform his constitutional functions as Deputy President while his trial continued at the ICC uninterrupted. The chamber considered that application and granted it conditionally by a majority decision, setting out a number of proceedings that he must attend in any event and reserving in the chamber a residual power to direct Mr. Ruto's attendance at other times. In the decision, the majority reasoned that the Rome Statute read as a whole and in its realistic context allowed the chamber sufficient discretion to grant an excusal on an exceptional basis to persons who have important functions of an extraordinary dimension to perform, and the chamber reasoned the functions, not merely the status of the Deputy President of a country, would qualify the holder for such an excusal. Implicit in the decision is the need to avoid the trial being slowed down or bogged down by collateral pressures upon the trial generated by any tension between the legitimate demands and other circumstances of his office on the one hand, and on the other hand, the perfectly justified requirements of international law so clearly reflected in the Rome Statute that every individual, regardless of office, must submit to the imperatives of accountability for their conduct, such as those in the nature of the crimes described in the Rome Statute. In the Chamber's view, those imperatives of accountability recommended a trial that proceeded in full celerity without interruption as commanding the greater concern of the foreseeable circumstances of the sort of tension mentioned above. But in granting the excusal, the Chamber made sure to stress that the excusal that was permitted Mr. Ruto was, quote, strictly for purposes of accommodating the demanding functions of his office as Deputy Head of State of Kenya, and not merely to gratify the dignity of his own occupation of that office, unquote. The prosecution has appealed against the Chamber's decision. The appeal remains pending. In the meantime, the prosecution has also requested the Appeals Chamber to suspend the operation of the Chamber's decision granting the excusal, pending the Appeals Chamber's decision on the merit of the appeal. That suspension was granted. In the result, Mr. Ruto will have to be present throughout his trial, pending the decision of the Appeals Chamber on the merit of the case. And on that note, the record will reflect that Mr. Ruto is present in court today. The date I pause to say that that, in any case, was one of the conditions originally indicated by the trial chamber in the excusal decision. The date for the commencement of trial was initially set as the 10th of April 2013. That date was vacated and set to the 28th of May 2013. The latter date was again vacated and finally set to the 10th of September 2013, that is today. To persons who are not students of comparative criminal justice systems around the world, it may seem strange, indeed, that the trial date had been set 3 times. But everyone should be reassured that there is nothing at all unusual about that. In some criminal justice systems, this is a very normal occurrence. The idea being that even setting trial dates and adjusting them give the parties a date, a time frame that guides their preparation for trial. It is better to set a trial date and adjust it as needed than to defer setting a trial date at all until all the procedural wrinkles in a case have been ironed out. The latter course would lead to greater delay, some may think, in setting a real trial date. Considering that procedural wrinkles in any complex case are always present. We have now finally arrived at the date for the commencement of the trial. We will next read the charges to Mr. Ruto and Mr. Sang, following which I will invite them to enter their pleas. In a moment, I shall call upon the court officer to read a synopsis of the charges section of the charging document. But before I do that, I note that Mr. Ruto and Mr. Sang have each individually filed a declaration of understanding of the charges. In those declarations, Mr. Ruto and Mr. Sang each confirmed that he has read the updated document containing the charges in its entirety and was duly informed in detail of the nature, cause, and content of the charges against him, and in a language he fully understands and speaks. Is that the case, Mr. Khan?
It is, Mr. President.
Thank you. And Mr. Kigen-Katwa?
Yes, it is, ma'am.
Thank you very much. Okay, the court officer will now only need to read the synopsis of the charges against the 2 accused persons in the charges section of the document containing the charges. Court officer, please read the synopsis.
Yes, Mr. President. William Samoei Ruto committed the crimes charged below as an indirect co-perpetrator with others pursuant to Article 25(3)(a) of the statute. Mr. Ruto, together with other key members of the network, together with Joshua Arap Sang, had a common plan, the goal of which was to attack particular parts of the civilian population due to their perceived affiliation with the Party of National Unity, PNU, permanently expelling them from the Rift Valley, and to gain power and create a uniform ODM voting bloc. It was carried out through the network's subordinates, supporters, and direct perpetrators. As the anointed leader of the Kalenjin people, Mr. Ruto carried out essential contributions to the common plan. His contributions included: 1. Using his authority in the Rift Valley to mobilize supporters for the network and to implement the common plan. 2. Using anti-PNU rhetoric and preparatory meetings and events to create an atmosphere of anti-PNU sentiment and fear among PNU supporters. 3. Providing direct perpetrators with weapons, food, and other logistical necessities. 4. Financing the network. 5. Coordinating the implementation of the common plan via coordination of logistics. And 6. Providing instructions to subordinates and direct perpetrators on where to obtain instructions. Joshua Arap Sang is criminally responsible for the crimes charged below, pursuant to Article 25(3)(d) of the statute. He intentionally contributed to the commission of the crimes committed by a group of high-ranking members of the network led by William Samoei Ruto, acting with the common purpose of attacking particular parts of the civilian population due to their perceived affiliation with the Party of National Unity, PNU, permanently expelling them from the Rift Valley, and to gain power and create a uniform ODM voting bloc. By virtue of his position with CAS FM as a key broadcaster, Mr. Sang placed his show, Li Ni Emet, at the disposal of the organization. Mr. Sang, first, broadcast propaganda against PNU supporters prior to the attacks. Second, broadcast preparatory meetings and event locations. Third, used his show to advertise the meetings of the organization. Fourth, fanned the violence through the spread of hate messages explicitly revealing desire to expel the Kikuyu. Fifth, broadcast false news regarding alleged murders of Kalenjin people in order to inflame the atmosphere in the days preceding the elections. 6. Call on perpetrators to and 7. Broadcast instructions during the attacks through the use of coded language in order to direct the physical perpetrators to the areas designated as PNU targets. Count 1. Mr. Ruto. Murder constituting a crime against humanity. Article 7(1)(a) and Article 25(3)(a) of the Rome Statute. William Samoei Ruto committed the crime of murder of civilians in Turbo Town, the Greater Eldoret area, Kapsabet Town, and Nandi Hills Town as an indirect co-perpetrator in violation of Articles 7(1)(a) and 25(3)(a) of the Rome Statute. Count 2. Mr. Ruto. Deportation of forcible transfer of population constituting a crime against humanity. Article 7(1)(d) and Article 25(3)(a) of the Rome Statute. William Samoei Ruto committed the crime of deportation or forcible transfer of population in Turbo Town, the Greater Eldoret area, Kapsabet Town, and Nandi Hills Town as an indirect co-perpetrator in violation of Article 7(1)(d) and 25(3)(a) of the Rome Statute. Count 3. Mr. Ruto. Persecution as a crime against humanity. Article 7(1)(h) and Article 25(3)(a) of the Rome Statute. William Samoei Ruto committed the crime of persecution with the intent to attack particular parts of the civilian population based on their perceived political affiliation by murdering, deporting, or forcibly transferring members of the said population in Turbo Town, the Greater Eldoret area, Kapsabet Town, and Nandi Hills Town as an indirect co-perpetrator in violation of Article 7.1h and 25.3a of the Rome Statute. Count 4, Mr. Sang. Murder constituting a crime against humanity. Article 7.1a and Article 25.3d of the Rome Statute. Joshua Arap Sang intentionally contributed to the commission of murder of civilians committed by a group of persons acting with a common purpose in Turbo Town, the Greater Eldoret area, Kapsabet Town, and Nandi Hills Town, in violation of Articles 7.1a and 25.3d of the Rome Statute. Count 5, Mr. Sang. Deportation or forcible transfer of a population constituting a crime against humanity. Article 7.1d and Article 25.3d of the Rome Statute. Joshua Arap Sang intentionally contributed to the commission of the crime of deportation or forcible transfer of a population committed by a group of persons acting with a common purpose in Turbo Town, the Greater Eldoret area, Kapsabet Town, and Nandi Hills Town, in violation of Article 7.1d and 25.3d of the Rome Statute. Mr. Sang, persecution as a crime against humanity. Article 7.1h and Article 25.3d of the Rome Statute. Joshua Arap Sang contributed to the commission of the crime of persecution committed by a group of persons acting with a common purpose and with the intent to attack particular parts of the civilian population based on their perceived political affiliation by murdering, deporting, or forcibly transferring members of said population in Turbo Town, the Greater Eldoret area, Uruma, Kimumu, Langas, Yamumbi, and Kiamba, Kapsabet Town, Nandi Hills Town, in violation of Articles 7.1h and 25.3d of the Rome Statute. Thank you.
Thank you very much, Court Officer. As noted, the updated document containing the charges is numbered consecutively from counts 1 to 6. Counts 1, 2, and 3 applying to Mr. Ruto, and counts 4, 5, and 6 applying to Mr. Sang. The accused will enter their pleas accordingly. Mr. Ruto, please rise to take your plea. William Samuel Ruto, you have been charged in count 1 with murder constituting a crime against humanity under Article 7.1a and Article 25.3a of the Rome Statute. How do you plead, guilty or not guilty?
Not guilty.
And in count 2, you have been charged with deportation or forcible transfer of population constituting a crime against humanity under Article 7.1d and Article 25.3a of the Rome Statute. How do you plead, guilty or not guilty?
Not guilty.
Count 3, you have been charged with persecution as a crime against humanity under Article 7.1h and Article 25.3a of the Rome Statute. How do you plead, guilty or not guilty?
Not guilty.
Thank you very much. You may resume your seat. Mr. Sang, Would you please rise? Thank you. Joshua Arab Sang, you have been charged in count 4 with murder constituting a crime against humanity under Article 71A and Article 25(3)(d) of the Rome Statute. How do you plead? Guilty or not guilty?
Not guilty, Your Honor.
In count 5, you have been charged with deportation or forcible transfer of a population constituting a crime against humanity under Article 71D and Article 25(3)(d) of the Rome Statute. How do you plead? Guilty or not guilty?
Not guilty, Your Honor.
And in count 6, you have been charged with persecution as a crime against humanity under Article 71H and Article 25(3)(d) of the Rome Statute. How do you plead? Guilty or not guilty?
Not guilty.
Thank you very much. You may resume your seat. We have come to the end of the plea entry. Now we will turn to the opening statements. Madam Prosecutor, how much time are we looking at?
Us about an hour.
Very well, madam. You may proceed.
Thank you, Mr. President. Mr. President, Your Honors, the case we are about to commence concerns the individual criminal responsibility of the two accused, Mr. William Samuel Ruto and Mr. Joshua Arab Sang. This is, Mr. President, for the roles they are alleged to have played in the terrible crimes committed against the Kenyan people during the 2007 post-election violence. Mr. Ruto, as a powerful politician, for his alleged role in planning and organizing violence to achieve his political ambitions and satisfy his thirst for political power. Mr. Sang, a radio broadcaster, for his alleged role in using his public voice to further Mr. Ruto's criminal plans. From late December 2007 until early January 2008, Kenya was engulfed in a wave of political and ethnic violence following the results of a hotly contested presidential elections. The regions worst affected by this violence was the Rift Valley province. It is the violence in the Rift Valley, in particular, the districts of Nandi and Uasin Gishu, that is the subject of the present case. Once the dust has settled and the flames were doused, over 200 people lay dead and another 1,000 people were injured in these two constituencies alone. Over 50,000 homes were razed to the ground in the Uasin Gishu alone, the highest number in any single district in Kenya, and tens of thousands of people fled the area. Estimates of the number of internally displaced Kenyans from the Rift Valley range from 200 to 4,000. It is difficult to imagine the suffering or the terror of the men and the women and children who were burnt alive, hacked to death, or chased from their homes by armed youths. A vast majority of the victims of the violence in the Nandi and Uasin Gishu districts were ethnic Kikuyu who were or were perceived to predominantly be supporters of the Party of National Unity, commonly referred to as the PNU. The PNU was the main opposition in the 2007 elections to the Orange Democratic Movement, or the ODM, a party in which Mr. Ruto was a powerful leader. The Kikuyu ethnic group was a minority ethnic group in the Rift Valley. The majority, being the Kalenjin ethnic group, had historically perceived the Kikuyu to be the unwelcome settlers who had misappropriated what the Kalenjin considered to be their ancestral land. The question posed in these proceedings is, who is responsible for the violence? The prosecution asserts that the two accused, Mr. William Ruto and Mr. Joshua Arap Sang, are among the most responsible for the crimes of murder, of persecution, and deportation that occurred in the Rift Valley. The prosecution will demonstrate that Mr. Ruto and his syndicate of powerful allies, including his co-accused, Mr. Sang, sought to exploit the historical tensions between Kalenjin and Kikuyu for their own political and personal ends. Your Honors, the evidence which the prosecution will present will prove, beyond a reasonable doubt, that the crimes for which Mr. Ruto and Mr. Sang are charged were not just random and spontaneous acts of brutality. On the contrary, this was a carefully planned, coordinated, and executed campaign of violence, specifically targeting perceived PNU supporters, targeting their homes and targeting their businesses. Mr. Ruto's ultimate goal was to seize political power for himself and his party through violent means. And this was in the event that he could not do so through the ballot box. By exhorting his supporters to rid the Rift Valley of the Kikuyu, Mr. Ruto and his network also sought to permanently alter the ethnic composition of the area in order to consolidate his political power base amongst the Kalenjin. As the senior trial lawyer, Anton Steinberg, will explain in more detail, the prosecution will prove that this campaign of violence was conceived, planned, and implemented by a network of influential Kalenjin. They were led by their anointed leader, Mr. William Ruto, a powerful political figure in the Rift Valley. Over a period of 18 months prior to the elections, in a series of private and public messages, Mr. Ruto assembled this network using to his advantage existing Kalenjin community structures and customs. He assigned responsibilities. He raised finance. He procured weapons and hosted meetings in furtherance of the criminal aims of the network. Using community structures, he gathered together an army of loyal Kalenjin youth to go to war for him in the event of an election loss. He also stoked the flames of anti-Kikuyu sentiment, both personally at public rallies and indirectly through other influential speakers and through the media. And when the election was lost, he gave the order to attack. In this way, he made an essential contribution to the violence that ensued. The main mouthpiece used by Mr. Ruto to spread his message was his co-accused, Mr. Joshua Arap Sang. Mr. Sang was a popular radio presenter at KAS FM, a major Kalenjin radio station. Mr. Sang placed his prime-time radio show at the disposal of the network to spread their message and coordinate their activities. Mr. Sang broadcast anti-Kikuyu rhetoric, spread the word of Mr. Ruto's rallies, and even helped to coordinate the actual attacks through decoded messages. In this way, he too contributed to the violence. Mr. President, Your Honors, the prosecution submits that under international criminal law, each of the accused is therefore criminally responsible for the acts of murder, deportation, persecution that are in the document containing the charges. Before I hand over to Mr. Steinberg, I feel it is necessary for the benefit of all interested parties who may be following these proceedings to outline how we have arrived at this point. There has been, Mr. President, much speculation and often inaccurate public and political discourse regarding the prosecution's reason for investigating the post-election violence in Kenya. Today, too many people have forgotten the intensive efforts of the International Criminal Court throughout 2008 and 2009 to encourage Kenya to establish genuine national proceedings. Let me emphasize that the prosecutions intervened in this matter only after the Kenyan efforts to establish a domestic mechanism to investigate the violence failed. Allow me, Mr. President, just to briefly recall the history of this case. On the 28th of February 2008, international mediation efforts led by Mr. Kofi Annan, chair of the African Union panel of eminent African personalities, resulted in the signing of a power-sharing agreement between President Mwai Kibaki and Prime Minister Raila Odinga. The agreement established 3 commissions: the Commission of Inquiry on Post-Election Violence, or the CPEV, the Truth, Justice and Reconciliation Commission, and the Independent Review Commission on the 2007 general elections. On the 15th of October that year, the CPEF published its final report, and the report recommended the establishment of a special tribunal to seek accountability against persons bearing the greatest responsibility for the crimes relating to the 2007 elections, failing which the Commission recommended forwarding the information it collected to the International Criminal Court. Unfortunately, despite efforts to pass necessary legislation to take this process forward, by November 2009, the process had reached a stalemate. Nor did there appear to be any reasonable prospect of a resolution. It was only then that my predecessor, the former prosecutor, announced his intention to request permission from the judges to open an investigation, a decision which was fully supported at the time by the Kenyan government. This approach, Mr. President, was consistent with the International Criminal Court's mandate as a court of last resort. I should also emphasize that investigation and prosecution have been subject to the independent judicial scrutiny at various key stages. In 2010, the judges of the pretrial chamber authorized the prosecution to commence its investigations after concluding that there was a reasonable basis to believe that crimes within the jurisdiction of the court have been committed. In 2011, the judges concluded that there were reasonable grounds to believe that Mr. Ruto and Mr. Sang were responsible for these crimes, and they issued summonses for their appearance at court. And finally, Mr. President, on the strength of a summary of the prosecution's evidence, the pretrial chamber found substantial grounds to believe that the 2 accused persons were criminally responsible for the crimes against humanity of murder, deportation, or forcible transfer, and persecution. Moreover, both the pretrial chamber and the appeals chamber rejected the government of Kenya's challenge to the admissibility of the cases, finding that there were no national proceedings against the suspects for the conduct alleged before the ICC. Despite the call that has been made in certain quarters to have the matter referred back to Kenyan tribunals, this situation has still not changed. Mr. President, Your Honors, this trial is the culmination of a long and difficult investigation. It has been fraught with cooperation challenges and obstacles relating to the security of witnesses. Many victims and witnesses have been too frightened to come forward. Others have given statements but subsequently sought to withdraw from the process, citing intimidation or fear of harm. Worrying evidence, Mr. President, has also emerged of attempts to bribe witnesses to withdraw or recant their evidence. The very fact, Mr. President, that I stand before you at the opening of this trial today, Your Honors, is something of an achievement in itself. Let me also caution, Mr. President, those persons behind the ongoing attempts to intimidate and bribe the ICC witnesses. These are serious offenses under the Rome Statute, and they carry hefty sentences upon conviction. The prosecution is investigating. We will get to the bottom of it and ensure that those responsible also face justice. This trial, Mr. President, must be allowed to run its course without interference with the activities of witnesses of either the prosecution or the defense. The prosecution has now the opportunity and the responsibility to present its evidence in full before this chamber in order to prove the charges beyond reasonable doubt. As accused before this court, Mr. Ruto and Mr. Sang will enjoy all the rights and privileges under international law and under the Rome Statute, the rights and privileges that have been agreed upon as fair and as just by 122 member states around the world, including Kenya. The ICC, Mr. President, as the Kenyan Attorney General has himself admitted and recognized, is a Kenyan court. The rights that the court guarantees include the right to be presumed innocent. If the accused are indeed guilty, however, the victims of the awful violence that racked Kenya in 2007 and 2008 deserve to see them punished. This is a matter for the chamber alone to decide. The only issue at hand in these proceedings is the guilt or innocence of the accused before the court. And this is not a trial of Kenya or of the Kenyan people. It is not about vindicating or indicting one or other ethnic group or political party. It is not about meddling in African affairs. This trial, Mr. President, Your Honors, is about obtaining justice for the many thousands of victims of the post-election violence and ensuring that there is no impunity for those responsible, regardless of power or position. Your Honors, thank you for your patience. I will now, with your permission, like to hand over to Mr. Anton Steinberg, lead counsel for the prosecution. And Mr. President, Mr. Steinberg will give a more detailed outline of the evidence that the prosecution will present in support of the charges against the accused persons. I thank you.
Thank you very much, Madam Prosecutor. Mr. Steinberg, before you proceed, a small matter of timekeeping. I understand that we have to rise at 11 o'clock today for a 30-minute break. Would your presentation be accommodated within that time?
Your Honours, it's going to be touch and go. I can't give you an exact answer on that, but it is possible that we will be able to accommodate in that time.
Fair enough. Please proceed.
Before I commence, Mr. President, I have some visuals to show. May I just confirm from the court officer if these are ready to go?
Mr. President, if I may, the audiovisuals are now, everything is set and ready to go. The OTP can show the slides from their computer themselves, and in order for parties and participants to be able to see them, please press the button PC1 in the black remote control that you have next to your screens. All the documents that are going to be showed are public and therefore will be broadcasted outside this courtroom. In the event of any audio, visual images or any audio recordings, no interpretation will be provided and no transcription either. Thank you.
I'm not seeing anything.
PC1?
I'm on
PC1?
It's on this computer. It's on your computer as well. Maybe I need to press something here. Showing here, but I'm not getting it here. I'm on PC1.
Mr. Steinberg, just while they're fixing your get up over there, just so you're not confused, the 30-minute break doesn't mean you have to stop. It means just trying to check for time. You may continue. We'll be resuming at 11:30, in which you will then proceed. I think we go from 11:30 to 1, so you can continue after that. We know that we have a full house in the public gallery today. They don't need to wait. So if anybody who wants to leave from the public gallery can just quietly rise and depart, they will not be disturbing the proceedings inside the courtroom. So I thought I'd make that clear. You may proceed now.
Thank you, Mr. President. If everybody is ready, Mr. President, Your Honours, as the prosecutor has indicated, I will now present a more in-depth explanation of the prosecution case and how we intend to prove that case. Each accused faced three counts of crimes against humanity, namely murder, deportation or forcible transfer of a population, and persecution, committed during the period 30th of December 2007 until 16th of January 2008. These charges relate to violence committed in 8 locations in the Rift Valley, more specifically in the districts of Uasin Gishu and Nandi. The specific locations in question are the towns of Turbo, Kapsabet, and Nandi Hills, and 5 locations in the Greater Eldoret area, namely Kiamba, Langas, Yamumbi, Haruma, and Kimumu. The map presently before the Chamber gives an indication of the location of the incidents within the districts of Uasin Gishu and Nandi, and their relative locations. These attacks covered a significant geographical spread and temporal scope. Your Honours, the evidence will establish that the attacks charged were not incidents of spontaneous violence. Rather, they were the result of careful planning. Nor was the violence random. The evidence will reveal that the targets of the attacks were specifically the Kikuyu population and other perceived PNU supporters, along with their homes and their businesses. This attests, Your Honours, to the discriminatory intent behind these crimes. The prosecution will present up to 22 victims and witnesses, common Kenyan people, who will describe the attacks on each of these locations. They will testify that the attacks were preceded by the sounding of the traditional Kalenjin Nderu, or war cry. They will describe how large groups of Kalenjin youths, armed with traditional weapons such as bows and arrows, and many dressed for war, descended upon one location after another. Witnesses will testify how they saw large numbers of these youths ferried into certain locations by lorries. The attacks focused on areas known to be predominantly occupied by PNU supporters, mostly Kikuyu. In groups, and with the help of locals who lived in the areas, they identified and systematically torched houses and businesses belonging to PNU supporters and looted all their belongings. Kikuyu who were found were caught and attacked on sight with weapons such as arrows or pangas, and many were killed or gravely injured. Certain witnesses will also identify members and associates of the accused network as leading the attacks in Turbo Town, Kumumu, Kapsabet Town, and Nandi Hills Town. Others will testify that network members provided transport, food, and refreshment to the attackers. As a result of these attacks, at least 200 people were killed and over 1,000 injured. Tens of thousands were displaced. In one of the worst incidents at Kiamba, PNU supporters sought refuge in the Assemblies of God Church, a holy place where they expected to be safe. However, the attackers barricaded the victims inside this church and set it alight. Many of the occupants were trampled to death or burnt alive. Others who managed to escape the flames were hunted down and hacked to death. In total, between 17 and 35 people of all ages were killed. The first prosecution witness, witness 536, will testify about this incident. In the slide currently before the chamber, you can see the remains of bicycles which, amongst other objects, were used to barricade the doors of the church. Your Honours, the prosecution alleges that two of the men most responsible for these attacks are the two accused before court. Who then are the two accused? The first accused, Mr. William Ruto, was and is the anointed leader of the Kalenjin and a powerful politician in the Rift Valley. This short video clip shows scenes of a ceremony at which this title was bestowed upon the accused. Note also the images of youth being ferried to the ceremony on the backs of lorries. Mr. Ruto had unsurpassed access to the community's resources, including manpower, funds, weapons, and transportation. These were all crucial for the implementation of the common plan, namely to resort to violent action in the event of an election loss. Until recently, Mr. Joshua Sang was the host of one of the, if not the most popular shows on Kalenjin radio station, Kass FM. This was the principal source of information and political discussion across the Rift Valley. He was therefore in the perfect position to help Mr. Ruto to build and control his network and to contribute to the execution of the common plan. Due to the enormous popularity of his show, Mr. Sang had carte blanche over the contents and the topics discussed on his program. Mr. Sang was fully aware of his influence over the community. He used that influence to steer public opinion in favor of Mr. Ruto and against the PNU. He placed his show at the disposal of the network for the furtherance of their plan. I will return shortly to describe in more detail the nature of the common plan and the contribution of the accused. First, however, it is important to provide some context. In order to understand the accused's motive and opportunity to commit the crimes for which they are charged, it is necessary to have an insight into the political and historical background against which these crimes were committed, including the Kenyan political environment. This context will be provided through the evidence of, amongst others, the expert witness P464, who will examine the historical roots of the violence from a political, sociological, and anthropological perspective. The prosecution will also call two political overview witnesses, witnesses 326 and 323, and further insights will be provided by certain witnesses to the events in question who have direct knowledge of the perceptions of the population of the Rift Valley. Your Honours, historically, Kenyan politics has been heavily influenced by ethnic loyalties and tribal allegiances. Since independence, history has shown that the winning presidential candidate has tended to patronize members of his own tribe with land and other benefits. This system is sometimes described by political scientists as neo-patrimonialism. In basic terms, it is understood and acknowledged that people connected with the president, that is, belonging to the same tribe, are given preferential access to positions in government, land grants, better jobs, improved infrastructure for their districts, and contracts for the most lucrative business deals. I digress, Your Honours, to mention that I am aware that the term tribe may be regarded as some as being offensive, but this is the term that many of the witnesses use to describe their own and other ethnic groups in Kenya. And for this reason, the prosecution will also use it. Land, Your Honours, in particular, has always been a hotly contested issue in Kenya and in particular in the Rift Valley. The Kalenjin considered the Rift Valley to be their historical and ancestral homeland. In the years preceding independence and afterwards, Your Honours, a number of Kikuyu have resettled from Central Province to the Rift Valley. Many of them have benefited from the resettlement of colonial farms. Some of these farms had, in turn, been seized by the colonialists from earlier Kalenjin and Maasai occupants. Therefore, many Kalenjin resent the settlement of non-Kalenjin tribes in the Rift Valley and consider that they have misappropriated Kalenjin ancestral land. In 2005, Kenya held a constitutional referendum that raised the issues of land ownership and decentralization of power held by the executive branch of government. The Kikuyu and Kalenjin tribes took opposing positions on the referendum. 2007 presidential candidate Raila Odinga, supported by the Kalenjin, Luos and other tribes, opposed the proposed constitutional amendment. To make it easy for people to vote, symbols were used, an orange for no and a banana for yes. After the success in opposing the referendum, Raila Odinga and other prominent no politicians, including the first accused, William Ruto, formed the Orange Democratic Party, named after the no symbol, the orange, commonly referred to as the ODM. And it is this party for which Mr. Ruto campaigned in 2007. In keeping with the orange position taken during the 2005 referendum, the ODM campaigned in the Rift Valley on a platform that strongly resonated with the Kalenjin ambition, that is, to control their province's natural and other resources and expel members of other tribes in order to reclaim lands, jobs and property. This political philosophy is sometimes referred to in Kenya as Majimboism. The ODM and the PNU were two of the main parties which contested the 2007 the 2007 presidential elections. By the time campaigning for the 2007 elections had begun, Mr. William Ruto was the most influential politician in the Rift Valley. William Ruto and Joshua Sang knew what was at stake in these elections, namely real political power with all its attendant benefits for the winner and his supporters, and marginalization and disenfranchisement for the loser. Knowing this, the prosecution's evidence will show that Mr. Ruto created a network by enlisting other influential community leaders and supporters, elders, youth leaders, ex-military personnel, businessmen, and importantly, Mr. Joshua Sang as the media spokesperson. The network's plan, repeated time and again at rallies and meetings, was war. In the event that power could not be obtained politically, then this network planned to use organized violence on an unprecedented scale to rid the Rift Valley of its political and ethnic opponents once and for all. Let me now briefly describe the structure of Mr. William Ruto's criminal organization. A network made up of influential Kalenjin associates, including Mr. Sang, and loyal, disenfranchised, and obedient Kalenjin youth. I should state at the outset that the criminal organization in question, which the prosecution has dubbed the network for ease of reference, was not a formal military or governmental body. It did not have formal ranks, officers, or letters of appointment. It did not keep formal records in the form of cabinet minutes, nor did it report its activities via military situation reports. Rather, this network was a criminal organization in the style of a mafia group or a triad organization, namely an association, in fact, of individuals connected by ethnic ties and a shared criminal purpose. None of this, however, means that it was any less real or any less organized. It had a clear hierarchy and chain of command, with Mr. Ruto at the apex. It displayed well-defined roles assigned to its members, all of whom contributed in one way or another to its ultimate goal, to rid the Rift Valley of its political and ethnic opponents. Your Honours, this diagram illustrates the various constituent elements of the network and various prominent members thereof, including the political element, financial element, military planners and strategists, media support from Mr. Sang significantly, and the tribal structures that provided support, manpower, and logistics. These various constituent parts of the network contributed as follows. Politically, Mr. Ruto's associates within the network included prominent and influential local politicians and community leaders. They gave their endorsement to the plan by appearing at public rallies and supporting Mr. Ruto's rhetoric, as well as contributing to his war chest. Financially, the network received funding from wealthy Kalenjin businessmen and community foundations. And Mr. Ruto personally contributed his own money to ensure the common plan was implemented, handing out cash to those who attended meetings and pledging rewards to those who killed perceived PNU supporters or destroyed their properties. Militarily, the network's hierarchical structure had a chain of command and system of reporting. It included ex-security servicemen appointed to coordinate and oversee the execution of the attacks, the names of whom appear on this slide. Reporting to these so-called commanders were divisional leaders, and under them, thousands of Kalenjin youth enlisted to perpetrate the violence itself. As I've already mentioned, Mr. Joshua Sang was a key collaborator and the media spokesman. Finally, and crucially, the network drew on existing tribal structures to strengthen and legitimize its existence and objective. Traditional Kalenjin elders endorsed and blessed Mr. Ruto as their leader in 2006, as we've just seen. They exploited traditional circumcision and oathing ceremonies of Kalenjin youth in order to indoctrinate and train large numbers of warriors before the elections. They contributed funding and recruited youth to take part in the attacks. They helped to corral people to the preparatory meetings and acted as watchdogs in their community to ensure the participation of every Kalenjin male in those areas, meting out punishment to those who did not support William Ruto and his party. Punishments included public humiliation, flogging, and forcing them to pay penance in livestock, some of which were used to feed warriors on the ground. And after the violence, they performed cleansing ceremonies to absolve youth involved in the crimes of any crimes they had committed. Therefore, Your Honours, while it may not have resembled a traditional state or state-like organisation, this ad hoc network nevertheless satisfies the requirements of an organisation for the purposes of the contextual elements required for crimes against humanity. It had the means to carry out organised, large-scale attacks which infringed upon basic human values. And it executed the plan on the instruction of Mr. William Ruto, when the party that Mr. Ruto supported lost the 2007 elections. The common plan that I have just described did not spring up overnight. It was carefully created over a period of nearly 18 months prior to the elections. The plan was developed and implemented in a series of small and large planning meetings and public rallies, starting in mid-2006 and continuing right through to January 2008. The meetings and rallies occurred in many areas, including Mr. Ruto's home in Sugoi, and in the locations where the attacks later took place: Eldoret, Turbo, Kapsabet, and Nandi Hills. The slide before the Chamber now depicts the locations of various meetings and the rallies that were held, including those held at Mr. Ruto's Sugoi home. Witnesses who were present at certain of these meetings and these rallies will describe what they saw and heard, including members of the network planning and organising to permanently rid the Rift Valley of the Kikuyu and other perceived PNU supporters. In the lead-up to the election, Mr. Ruto, as the leader of the Kalenjin, was the main speaker at a number of large rallies. This short clip depicts Mr. Ruto addressing one of the many rallies preceding the election.
Your Honour, I wonder, is sound going to be played? I would ask that it would be played.
I do not propose to play sound, Your Honours, mainly because they're not in English.
You may proceed.
Thank you. Let me make it clear, in case my learned friend misunderstands me. I do not allege that what was said by Mr. Ruto at this particular rally, in this particular clip, constitutes evidence of the crimes we allege. The evidence which the prosecution will lead, however, will demonstrate that these were not merely innocent election rallies. He and his fellow speakers used them as a platform to complain to his Kalenjin audience about the unfairness of long-standing and deep-rooted tribal issues. Mr. Ruto repeatedly told his Kalenjin audience how land and employment opportunities were wrongfully appropriated by the Kikuyu and others who did not belong in the Rift Valley. He warned them that without vigilance, the upcoming election would be rigged, and declared directly or through the use of parables that non-ODM supporters should be evicted from the Rift Valley, saying, for instance, that they were weeds which needed to be removed. Witnesses will also testify how Mr. Ruto consistently referred to Kikuyu using derogatory terms like madoa-doa, meaning spots or stains, saying that these spots or stains must be removed from the Rift Valley. And you will hear that Mr. Sang, for his part, advertised the time and place of these rallies, encouraging large crowds of people to attend. In addition to these public rallies, smaller private meetings were held as early as June 2006. The first meeting was held at Mr. Ruto's home in Sugoi, on the outskirts of Turbo, which was the first area to be attacked by the network. Witnesses who attended these meetings will tell the Chamber that the agenda for these meetings was war. Furthermore, Mr. Sang and Mr. Ruto and others espoused anti-Kikuyu and anti-PNU rhetoric, arranged for the logistics necessary to carry out the attacks, namely funds, transportation, weapons, food and communications, etc. At other meetings, people were designated to call into Mr. Sang's radio show to express their support for ODM and for Mr. Ruto and to denigrate the PNU. Areas densely populated with Kikuyu and other PNU supporters were identified for attack. Locals familiar with the area were appointed to lead the attacks and to identify Kikuyu-owned property and businesses. At these meetings, village leaders were also instructed to hold local meetings to maximize the reach of the network's message of hate, and hence the number of people who would later respond to the call to drive out the Kikuyu from the Rift Valley. Immediately preceding and during the violence, local network commanders and youth congregated on the outskirts of the targeted locations in order to organize and coordinate attacks to ensure success. What then was the contribution of the accused to all of this? Mr. Ruto used his political and tribal authority and the traditional obedience and the tradition of obedience of the Kalenjin to their leaders to promote and impose the objectives of the common plan on the Kalenjin community. As I have already explained in some detail, he utilized political campaigns, public events, and private gatherings, as well as the media, to exploit the community's historic grievance and to plant the seeds that the PNU would steal or otherwise rig the elections. As the founder and leader of the network, he was the ultimate controlling hand behind the common purpose. In this way, he made an essential contribution to the common plan. Additionally, however, Mr. Ruto made a number of other essential contributions, such as supplying weapons and contributing finances and other necessities for the implementation of the attacks. Mr. Sang contributed to the common plan and ultimately to the crimes by placing his show Lene Emet at the disposal of the network. Mr. Sang was the voice of the post-election violence in the Rift Valley. He fanned the violence by spreading hate messages against Kikuyu and announcing that the election would be and then had been rigged. He himself attended certain planning meetings, so he knew very well what the ultimate aim of the spreading of anti-Kikuyu rhetoric was. Furthermore, he was on notice regarding the impropriety of broadcasting these types of messages, as his radio station had previously been sanctioned after the 2005 referendum for broadcasting hate speech. Mr. Sang also provided Mr. Ruto with a platform by which he himself could regularly address the entire Kalenjin community. He took calls from persons specifically designated by the network to spread its views and to serve its objectives. He promoted and reported on rallies and meetings, and significantly, he encouraged the network's perpetrators to participate in the attacks and directed them to designated target locations. On the strength of these contributions, both accused bear criminal responsibility under the Rome Statute and under international law. This evidence, if accepted by the Chamber, will make it very clear as well that the two accused had the necessary criminal intent required for conviction of the crimes charged. As the prosecutor mentioned earlier in her introduction, the ultimate aim of Mr. Ruto and his network was to drive his political opponents from the Rift Valley by violent means, to secure personal political power, and to consolidate Mr. Ruto's voter base in the Kalenjin community. By destroying the homes of his opponents and the use of extreme violence in combination, he and his network drove over 35,000 mainly Kikuyu victims from the two areas of the Rift Valley concerned. And perhaps at this stage I should just correct an inadvertent slip of the prosecutor. The number of estimated victims was not 200 to 4,000, but 200 to 400,000 in the Rift Valley alone. The clips which are now being shown to the court demonstrate, firstly, a makeshift IDP camp at the Turbo police station, where many Kikuyu fled for safety. And the second clip is a more formal IDP camp set up at the Eldoret Showgrounds. We seem to have lost that one.
Press backspace and see if that happens.
I think I will just proceed. It's not that important. Your Honours, these images bear mute testimony to the effectiveness of the accused common plan to forcibly remove political opponents from the area. I think I'm going to make it, Your Honours. Your Honours, the defence will have you believe that the post-election violence in the Rift Valley was not, in fact, the product of prior planning by the accused and his network, but rather the spontaneous response of the population to what they perceived as election fraud. They will allege that the prosecution's evidence to the contrary is a fabrication, and that many of the prosecution's witnesses have engaged in an elaborate conspiracy. They will point to alleged inducements offered to witnesses, whether by the prosecution or some other yet-to-be-identified third party, in order to falsely lay the blame at the feet of the accused. Indeed, the defence are obliged to do so, since the evidence against them, if accepted, is compelling. They are also obliged to point to some guiding hand behind the scenes in order to explain how such a disparate group of individuals could be persuaded to unite behind this shadowy scheme. The prosecution expects, although we don't know, as we have not yet been disclosed the defence's witness list, we expect the defense will rely on certain former prosecution witnesses who have now recanted their written statements, statements which they signed and confirmed the truth of, but who now allege that they were induced by members of the prosecution or other as yet unnamed parties to falsely implicate the accused. They allege in statements and in the media that sudden bouts of conscience have moved them to renounce their former versions and come clean. However, the prosecution will, if necessary, present evidence as to the true motives behind their actions, and that is that they have been bribed to do so. However, Your Honours, the Chamber should not allow itself to be distracted from the evidence before it. Your Honours will in due course determine whether or not the witnesses are truthful and reliable. To conclude then, Mr. President, Your Honours, the prosecution will prove beyond a reasonable doubt that the two accused, Mr. William Ruto and Mr. Joshua Sang, are criminally responsible for the attacks in Turbo, Greater Eldoret area, Kapsabet and Nandi Hills, and that they should be declared guilty of the crimes charged against them. I thank you for your attention.
Thank you, Mr. Steinberg. Before we rise, of course, I did not want to interrupt your flow, but I was rather attracted by the caveat you issued as regards the word tribe. If you learned that not too long ago the word was described in an eminent dictionary as an aggregate collection of a primary people living in barbarous conditions under a headman or chief, perhaps you might accept that ethnic group might be a better word to use, despite what your clients say.
I accept your Honour's admonition, but I'm afraid I will not be able to control the terms used by the witnesses. They will use their own terms. But
fair enough.
For myself, I think I can manage to use the term you've indicated. Thank you, Your Honour.
Mr. Ken, you will be prepared to proceed at 11:30. I take it?
Your Honour, unless the victim's representative goes first, and then perhaps I'm prepared to stand at any time.
Fair enough. And in that case, Ms. Anderetu, you'll go next?
Yes, I will be next after the break.
Thank you very much. So we will now rise for 30 minutes.
On rise, veuillez vous lever.